Good morning, everyone, to this parallel session about justice for children utilizing hybrid and innovative justice models. So, dear participants, dear speakers and panelists, we are very happy to welcome you to address this topic. But first, before starting, let me introduce you our panelists. On my left, Professor Elena Marchetti, professor at the University of Griffith in Australia. Elena is Deputy Chair of the Queensland Sentencing Advisory Council. I will not say more because all the profiles are also available online.
Yeah, that's fine.
So thank you, Elena. Professor Marchetti will explain us how hybrid and innovative justice practices are not simply practices that are old, outdated, and partially supported. They are, above all, practices that are commonly adopted and respected in a number of countries and territories for various types of matters. So we'll have a presentation from Professor Marchetti. Then let me introduce you Judge Thaher Zourai Yasser Khalil from Palestine. Mr. Khaled is head of the Juvenile Prosecution Directorate in Palestine. He's been working in the public prosecution over the 24 past years. Additionally, he is member of the National Council for Children in Palestine. Judge Thaher will talk today about the coordination between the formal justice system and the informal justice system, the importance of conducting the mediation through a community mediator, and the importance of accrediting community mediators. Let me then introduce Ms. Yumna Marlouf from Lebanon. Ms. Yumna is a practicing lawyer at the Beirut Bar Association. She is a lecturer at the Faculty of Law at the Saint Joseph University in Beirut. Ms. Yumna today will talk about justice for children utilizing hybrid and innovative justice model, and you will specifically focus on the case of Lebanon. Then welcome to Judge Mahmoud Abu Rouman from Jordan. Judge Mahmoud is a specialized personal status judge at the Sharia Court of Amman since 2011. Currently, he is a judge at the Appel Personal Court in Amman. Judge Mahmoud today will talk about the Sharia judiciary in the Hashemite Kingdom of Jordan, and he will explain us the structure of the Sharia courts in his country and the referral procedures for the community repairers. So these are our four distinguished panelists. I will finish quickly by myself. My name is Yann Colliou. I'm the head of Access to Justice sector at the Terre des Hommes Foundation. Thank you very much for attending this session. And we'll start with Professor Marchetti. Please.
Thank you, Yann, and the organisers of this conference. I hope you can hear me okay. I will start by acknowledging that I live and work on the lands of the Turrbal and Yagara peoples, and that Aboriginal and Torres Strait Islander people have inhabited the country that we call Australia for over 60,000 years. Australia was and always will be Aboriginal and Torres Strait Islander land, and as a non-Indigenous Australian, I want to highlight the violence and colonial and patriarchal structures that have imposed on Aboriginal and Torres Strait Islander people in Australia and on other First Nations people globally. Wherever I am, whether it's in Australia or in beautiful Madrid, I am a guest and recognise the value and the history of the people that have shaped these lands. Now, my presentation, I won't talk for very long because these esteemed guests will talk more about these practices, but I want to give you a bit of an overview of two areas. One is based on data that was gathered in conjunction with Jan, Patrick O'Leary, who's here, and Marta Gill, also from Terres de Hommes, we published a report on data that was collected by Terres de Hommes on customary justice practices in the Middle East and also Northwest Africa. The other focus, or the other part of my presentation, looks at Indigenous sentencing courts in Australia, very briefly, just to give you an idea of a hybrid process there. So we all know that children face a lot of challenges in accessing justice, and often when we look at trying to improve systems, we focus on the formal system rather than systems that sit maybe at the margins or outside of the formal system. And that's what this panel is about, talking about hybrid and innovative systems. So with the seminal report, it was an in-depth study, and you can find it online, of nearly 4,000 children 4,000 cases dealt with by customary justice systems in Lebanon, the Palestinian territories, Afghanistan, Egypt, and Burkina Faso. The data was collected in conjunction with customary justice actors. Some of them are here today. And it was very much a participatory action methodology, and it was collected between 2013 and 2019. You will see there that the majority of matters related to boys, in fact 81% of the cases were in relation to males, only 19% were in relation to females, and the highest number of females or girls were in Burkina Faso, then Lebanon, Egypt, and the smallest number were in Palestine. The age of the children ranged between 12 and 17 years of age. One of the other things that we looked at in the data was the affiliation of customary justice actors, and we felt that was important because it also speaks to how much, if they have an affiliation with formal systems, such as being public officials, then that practice sometimes may be brought into these customary justice processes. So you will see there that a number of the customary justice actors do have an affiliation with other public structures. They also have a lot of roles in a professional capacity, mainly dealing as a public official or in the business sector. Just briefly, some of the things that we found were beneficial about these practices was that matters, as we know in the formal system, take a very long time to, progress through the formal system. However, with these systems, the average sort of number of days that it took were between 1 to 19 days, and the shortest number was in Burkina Faso, as you can see, about 3 days. One of the other, criticisms of the formal process is the fact that children are often not heard. They're represented by legal representatives when it comes to courts, and their voices are therefore not present. But in these customary justice processes, and I'm sure the other panel members will talk more about this, we found that nearly 70% of children across all of the territories and countries had a voice in the process and were able to present facts about a matter. So now I want to move briefly to the situation in Australia. For the past 23 years, we've had what's called Indigenous sentencing courts, and they have had models that relate to children. They are a process that evolved because the people who set it up wanted to make the process more accessible for Aboriginal and Torres Strait Islander people, and also certainly for children. These processes generally involve judicial officers, magistrates or judges sitting with elders from the community, between 2 and 4 elders. They're often heard in a purpose-built courtroom or in a community centre. It is to do with criminal justice matters, and the person appearing before the court has to plead guilty, which there is criticisms about that. Now, before I talk about what the impacts have been, I will just show you a brief video. I'm sorry, but I'm going to have to play a short advertisement.
¿Estás buscando un coche de segunda mano? Autogiro tiene las mejores ofertas para ti. Por ejemplo...
He's a talented musician, But a scuffle with a security guard put the young Queenslander before a judge.
I tell you what, I would have ended up in jail for sure.
He credits Murray Court with putting his troubled youth days behind him.
My main job is working in schools. You know, every time I get another charge, it makes it more difficult to get things like a blue card.
Murray Court participants attend programs under the strict guidance of their Indigenous elders.
It's not just getting them a get out of jail free card. They have to put in the hard yards and they have to show us that they're willing to improve their life.
And that's been like that for thousands of years, and so looking up to elders is like it's a real big thing for me.
We teach them to heal. We teach them about their culture, and we teach them that, you know, there is some light at the end of the tunnel.
There are plenty of success stories.
So all the participants that we've had come through the Richlands Murray Court, not one of them have gone into custody in 4 years.
We're very, very fortunate to have a really good magistrate on our side who listens to what we say.
Not every Indigenous Queenslander has the right to use the Murray Court. The defendant has to plead guilty and they need to be referred by a lawyer or a magistrate.
I think the whole justice system needs to be dismantled. I don't mean burn down everything. I just mean just remove us from it and let us handle our business, and we'll get it right.
In a statement, the Attorney General Shannon Fentiman says Murray Court is working as intended, but the government is looking at expanding it.
I would like to see more people have access to it. Being put in jail really doesn't help. It really doesn't do anything for our people.
George Roberts, ABC News.
So what that tells you is that connection with community is very important for young people, and it's certainly a hybrid model that's used in most jurisdictions in Australia, but unfortunately, because the evaluations that have been done of these courts have mainly found that what it has improved are community building aims, for example, increasing voices of Aboriginal and Torres Strait Islander people in the courtroom. They're improving the relationship between the court and Aboriginal and Torres Strait Islander people and building trust. Unfortunately, that's not what drives policy in Australia, and so they haven't expanded at the rate we would like them. So just to conclude, as Jan said, my paper is about highlighting some hybrid and innovative justice practices. They're not practices that are simply old, outdated, and also they are supported. They're practices that are commonly adopted and respected in a number of countries and territories for various matters. They evolve to remain relevant, and that's an important point to remember, and it's important to allow them to evolve. But there are still questions we need to ask, and they're up on the screen. We need to think about how we can reconcile these practices with the formal system. We need to think about what the roles of the various players are, and we also need to do a lot more research on what the impact is on children, of course. So I'll leave it there.
So, thank you, Elena, for your presentation. Thank you for highlighting this seminal report, which has been published last year, last summer, if I remember well. That also show the lack and the importance of data when it comes to the formal system, but also the community systems. So thank you for that. Now we'll have the pleasure also to listen Judge Thaer. Judge Thaer will also explain us how criminal mediation in Palestine could be or is more effective when there is a collaboration between the formal justice actors, namely the prosecutors, and the community actors. So, Judge Thaer, thank you. The floor is yours.
السيدات والسادة الحضور الكريم.
Ladies and gentlemen,
شكرا لكم جميعا على المنصة. شكرا للخبراء.
thank you very much for giving me the opportunity to speak here today. Thank you, everyone. We experts are invited to these forums to support boys and girls throughout the world, especially today in Palestine. Palestine is represented here today to relate its experience. We're all professionals here, we know that, but the children of Palestine are being killed. They are being killed by the armed forces, by the occupying force in Palestine. But we have to say this loud and clear. A warm greeting to the children of Palestine. They are being killed by the occupying force. Palestine is a state. And I am here to represent Palestine. Having said that, I will finally move on to the presentation I prepared for today. Now, Palestine is characterized by a strong mediation system in all penal cases. I'll go straight to the point. Our judicial system is divided in several subsystems: the formal system, the tribal system, and a few others. What does this mean? This means that depending on the situation, a different type of judicial system can be used or resorted to. But in this presentation, I'll be focusing on the tribal system. The law prescribes, of course, through its statutes, what should be done in each and every situation. But separately, we've got this tribal system, which is comprised of a set of unwritten habits and customs, which can differ from the formal judicial system. Although I should point out that the official judicial system is based on the tribal system itself. But there is some distance between the formal system and the informal systems, and these two systems run parallel to one another. And so this begs the question, how can we better protect young boys and young girls? Palestinian legislators have passed a law which acknowledged the existence of tribal intermediaries. Tribal intermediaries are very important in Palestinian society, and they're widely accepted by the community. They play a pivotal role, and this means that judges and prosecutors from the official system do resort regularly to these mediators, and these mediators act as a link between society as it exists and operates and the formal system. And again, this is enshrined in Article 23 of the relative law. Article 23 prescribes exactly how little boys and little girls should be protected with the help of tribal intermediaries. So, to stress this, our legislation covers this. And this is something that the Prosecutor's General Office in Palestine takes into account. And this type of practice has led to concrete results. Good results, in fact. And I personally believe that this type of tribal organization, so to speak, helps take some of the pressure off of the children. In Palestine, we also have specialized prosecutors. They specialize in children's rights. And these prosecutors know how to interact with intermediaries to make sure that these procedures bear fruit. Because these intermediaries are social leaders, they know society well, and they play a pivotal role in this system. Intermediaries basically act as a very successful alternative to traditional justice systems when it comes to solving conflicts, settling disputes. Because, of course, what we don't want is for children to have to come to a hearing, to appear before a judge in very intimidating circumstances. And this is something we have been able to avoid using social intermediaries. Of course, the formal system also works, but young boys and girls are particularly vulnerable. We all know that, and that is why we also often resort to tribal systems. And these social intermediaries are chosen by the population. They make no money off of their work, no material benefits. They are volunteers. Okay, they do this on a volunteering basis, and so these intermediaries are picked out by judges or prosecutors' offices, and of course these intermediaries oftentimes are university graduates, and when they're not, they have a demonstrable track record working as such for 20-25 years even. So their professional profiles are, of course, taken into account because, they need to be skilled communicators, of course. Now, to share a few figures with you, we currently have 58 officially recognized intermediaries in Palestine. 13 of them are women, and 45 are men. And these men and women work on the field in this sort of tribal structure, in this tribal organization. So, 13 women and 45 men. Also, here on screen you can see our referral procedures. And these procedures detail how intermediaries are approached by the prosecutors and judges. According to our law, intermediaries first need to be contacted by the judge or the prosecutors before any decisions can be made. The intermediary needs to be sworn in, and then the process can begin. The hearing can, if needed, can begin. But before, we have to do this mediation. We have to run this mediation process. And then intermediaries, of course, once they've been selected and appointed, they speak to the children involved in a particular case, they speak to judges, they speak to prosecutors, they speak to everyone, and they do what they're supposed to do, they mediate. Once again, let me state this very clearly. We do this for the sake of our children, for their own good. And this means that intermediaries never get to impose their decisions. Children themselves need to accept this figure, this intermediary, okay? This is pretty much how the system works. This is a list of the regulations that mediators have to abide by. They have to obtain, of course, an official assignment from the prosecution. They need to be neutral, they need to be unbiased, fully independent. And then, as the process runs, the Juvenile Prosecutor's Office oversees, of course, the entire procedure. They supervise the work that is carried out by the mediator, and then with the approval of the ministry, if the mediator wishes to do it, can decide to pull out of the process if needed. But this is a decision that needs to be approved by us and the Ministry for Social Affairs, with which we work in close collaboration. Our statistics have shown that in 2024, 1,411 mediation were successfully conducted in children's cases. 724 of them, in fact, were settled out of court, so brilliant results. And I should also point out that mediators undergo training as well. Thanks to this, we've been able to limit juvenile detention from 3,000 underage children a few years back to about 100 in 2024. And this is thanks to these mediators. Once again, they are properly trained. I spoke very, very quickly, I'm sorry, but that was only because I didn't want to run over time. But I do hope you enjoyed the session. Once again, this model has proved very, very successful in Palestine. We've got lots of stats for you. So if you want to know more, feel free to reach out and we'll be happy to share our figures with you. Once again, before I conclude, I should say that Palestine is going to great lengths to survive, and the world should strive to better protect the children, boys and girls of Gaza. Thank you very much.
So thank you, Judge Thaher, for your presentation and for your dynamism. And congratulations for the work your country is doing for the last 10 years on criminal mediation, because this is not a new experience. We know that it started 8 or 10 years ago. I remember when I visited your country a few times, I've been also, I had the opportunity to meet some prosecutors, some community mediators. So your experience is great. Thanks a lot. And we keep also in mind that out of the 58 community mediators, you have already 17 or 16 women.
Yes.
So I'm sure also the progress will continue in that sense. So thank you very much. It's okay. So thank you very much, Judge Thaher, for your presentation. I also realized that we have the translation also in French and Spanish. Huh?
Yeah.
Fine. I would have known, but okay. So now I pass the floor to Miss Yumna. And thank you for explaining us also the situation of legal pluralism in Lebanon and the coordination between the different systems.
Thank you, Jan, and thank you for the organizers for organizing this very interesting panel for me also. So, of course, when we talk about the Lebanese system, the collaboration between state and non-state actors is not something new. It has always existed in Lebanon, because when we talk about the Lebanese legal system, we know that this system is characterized by its legislative and judicial pluralism, specifically in matters pertaining to family law. So in that perspective, the relationship between the state and religious communities is established as a relationship based on recognition. The state recognizes religious communities, and various religious communities. Even the Shema I put here does not show all the religious communities that are recognized in Lebanon, that are legally recognized. The scope of such recognitions varies, whether the community in question is historical or an ordinary law community, طوائف تاريخية أو طوائف حق العام. A historical community is a community which is defined as having existed before the creation of the state and having enjoyed privileges in matters pertaining to family law. And this is the reason why such historical communities have judicial and legislative powers that are recognized by the state. They preceded the creation of the state, and they exist even after the creation of the state, and this is why the state recognizes their jurisdiction and their powers in matters related to family law. On the other hand, ordinary law communities require proof of numerical importance and sustainability. And what we need to understand is that only the historical religious communities benefit from legislative and judicial powers in matters pertaining to family law, because we consider that these communities were pre-existent to the state, they preceded the state, and must keep on enjoying these powers and jurisdiction. To this date, there are 18 historical religious communities that are recognized by the state. Such a recognition may come as a shock for scholars who come from a different legal tradition, as they may perceive such recognition as contrary to freedom of religion. But it is exactly to protect freedom of religion that such legal pluralism exists. So it is in the name of freedom of religion that actually the state recognizes all of these 18 religious historical communities and gives them jurisdiction in matters pertaining to family law, because the idea is to preserve collective identities. And this is why no, we're still in the, yeah. And this is why, sorry, no, we can pass to the following slide, yeah. And this is why, sorry, the basis for such recognition is in Article 9 of the Constitution, which is the article that is related to freedom of religion. So the recognition of jurisdiction for historical religious communities is perceived as an extension of freedom of religion, both in its individual and collective dimension. So where does the child fall in all of this legal context? When a child is born, they ipso facto acquire a religious legal identity. They ipso facto have a religious identity, which is the religious identity of their father. And when they are under 18 of age, they follow the religious identity of their father. So if the father changes a religious community, automatically, ipso facto, the child follows the religious community of the father. And a child may not modify his religious affiliation or her religious affiliation unilaterally until they reach 18 of age. Yeah. The legal status of the child is fragmented. In that context, the legal status of the child is fragmented, since they are subject to various multiple jurisdictions and applicable laws depending on the matter at hand. So children are subject to both religious and state courts, to both state and religious laws. So for example, when we talk about birth registration and acquisition of the nationality, it's the state courts that have jurisdiction, it's a state law that applies. When we talk about filiation, guardianship, parental authority, it is the religious courts, at least when the child is born out of a religious marriage. When we talk about criminal liability, it's the state penal courts, the juvenile judge, civil liability, it's the civil judges, employment, the employment of children, forced labor, etc. It's the criminal courts and the labor courts and the labor law that would apply in Lebanon. So we have a situation of fragmentation. And this fragmentation that results from legal pluralism also provokes some challenges. Why do we have these challenges? Because there is a conflict of constitutional norms. It's a bit the question that was first asked by the first panelist. So we have a conflict of constitutional norms, as a famous scholar once said, Pierre Ranage, because we have, on one hand, Article 9 of the Constitution, which provides for the respect of all of this religious diversity and the religious personal status laws, but these religious personal status laws may sometimes come into conflict with other constitutional norms, the principle of equality, Article 7 of the Constitution, the freedom of conscience in its individual dimension, so the freedom to believe or not to believe, and the UN conventions that have been ratified by Lebanon and that have become part of the constitution. And this conflict in the situation of children specifically translates into a difference of treatment, in inequality or in discrimination between children born from wedlock or out of wedlock, certain discrimination in the guardianship rules that are applied by religious communities when deciding on the hadana, so on the right to receive and educate the child. In Lebanon, all of the religious communities set an age at which the child is returned to the father instead of taking into consideration as an only criteria the best interest of the child. Some take into consideration the difference of religion with the mother, her liability in the breakdown of marriage, etc. Other areas of tension is the minimum legal age for religious marriage, which is also set by all of the religious communities. And these provisions, when we look at them, may fall short of the international standards for the protection and the right of children. And so the next question, are the religious legal orders, are they really, do they have to abide by the principle of rules of hierarchy? Religious legal orders are external to the state. So in principle, they do not have to abide by the principle of rules of hierarchy, and they did not ratify the international conventions. It is the Lebanese state that ratified such conventions. But as another scholar says, Lena Hannaje, the state, by recognizing these religious laws, have to make sure that they abide by its own international obligations, or else the state itself would be in violation of this international convention. This is why this situation of conflict has created areas of tensions, naturally. So what are these areas of tension? First, it is in the area of guardianship and domestic violence against children. In 2008-2009, very quickly, juvenile judges in Lebanon ordered for children to be handed to their mother, despite religious decisions awarding hadana to the father, and despite objections of the religious courts. Also in 2014, a law on domestic violence was adopted, which provides for jurisdiction for judge in urgent, civil judge in urgent matters to take protection orders to protect children. And also currently, I mean, there are still areas where there is a need to collaborate more. These areas essentially reside in the need to protect children from forced marriages or early marriage, but we have found ways to move forward. So what are the ways of conciliation? Very quickly, currently the system relies on the idea of freedom of will of the individual. The idea being, if the individual is not happy with the religious laws, it is very easy for him or for her to exit the religious community, to choose to be subject to civil laws, and not to be subject to this jurisdiction. But this is not a real way of conciliation for different reasons. One, for the children, this choice does not exist. So a child cannot exit his religious community. Two, exiting the religious community is very, very difficult because the adherence to a community is not just a matter of belief, it's also social, economical, it has multiple dimensions, so it is not a way that is possible for every individual, but mostly people would like to remain in their religious communities and have their fundamental rights be respected. So people who believe, people who want to be subject to religious laws also should have the opportunity to have their fundamental rights respected. And I will finish. So what do we think is the way to go? It would be to the intervention of the state to maintain religious diversity, but also to push for the amendment of religious laws, which is possible because, as we said, religious laws can evaluate. They are not immovable or rigid. They evolve, and multiple interpretations exist. And this is what we saw with the amendments that were taken by the Sunni community and by the Druze community in the years 2000, etc. Thank you.
So thank you, Yumna, for presenting the complex situation in Lebanon when it comes to religious justice, especially. So thank you for that. Time's flying, so we'll pass the floor directly to Judge Mahmoud. Again, Judge Mahmoud is a personal status judge at the Sharia Court of Amman in Jordan. Please, the floor is yours.
بسم الله نبدأ السلام عليكم ورحمة الله وبركاته.
Good morning in the name of God. Well, first of all, I would like to thank Terre des Hommes. Thank you for disseminating justice values. Now, here I would like to say something inspired in the Quran. We are all part, or we are all descendant of dignity, of justice, and justice has a goal, which is to preserve people's dignity, and especially children's dignity. We should protect them particularly. That is why I would like to support why my Palestinian colleague has said. We need to work together so that these genocides would be over. We need to stop them. We are speaking about 45,000 children that have been killed. So please, this is enough. We need to stop this genocide. Now, that being said, let's talk about judicial jurisdiction, in particular the Sharia judiciary system. Now, we have a religious jurisdiction, and this jurisdiction entails different matters, civil matters, state matters, and we have 78 Sharia courts, including all instances, first, second, third instance, and these are divided into 12 provinces in our country. We have two main laws in our country. So on the one hand, we have law number 15 for 2019, as personal statutes law, and then we have the other law for 1958 with all its amendments, last amendment done in 2023. We have 14 Sharia judges. Now let's talk about this Sharia justice. It plays a role. It plays a role in the family dispute. So the Sharia judge will have every jurisdiction, every competence to give judgment, and this when the main goal is to protect the child's welfare. The judge will decide who to give the guardianship. Now, I will be very brief. Let's briefly see the structure of the Sharia courts. We have different rooms. We have, for example, departments rather. We have the public prosecution department, specializing in family and children disputes. It also plays a preventive role in every matter related to children, like divorce, guardianship, and so on and so forth, and always taking into consideration the interests of the child. We also have other offices that look to guarantee children's welfare. We have, as you can see, all these different departments, and we do have a lot of women working on them, which is something we are very proud of. Now we also have offices specifically related to family reconciliation, different types of works like raising awareness, reconciliation works are being carried out. Now, some of these were developed during the Ottoman Empire. We started with having certain courts, and since 1976, some of these tribal laws or courts were called for annulment, were cancelled. In spite of this, these courts, these tribal courts, do still play an important role because they play this important role before going to the first instance court. That we also have arbitration, we have mediation, and we have people working on arbitration, mediation, looking always at the best interests of the minor. We also have a certification, or a license rather, that can be approved for these mediators. The Sharia judge has certain competences in the different phases during the dispute. So, for instance, the judge will play a role before the dispute, during the dispute, but also after. There are certain reconciliation measures that can be developed in these courts. So first, the judge will organize a hearing with all the parts, and enough time is given to the mediator so that he will propose the most adequate solutions. Now, we have experienced many successful cases in the last year. In 2024, more than 84,000 cases were solved in family disputes. This represents a record when it comes to Sharia justice. Now, when it comes to coordination between different judicial bodies, let me say the following. There is a great coordination. We work so that we can find friendly solutions, and always putting at the center of every decision the welfare of the children. And last but not least, challenges and needs. Of course, there is much room for improvement, and we have many challenges ahead, but we are currently under a transformation phase. We have also been working on with digital tools, and this has allowed us to tackle challenges, cross-border challenges as well. In spite of these, as I said, there is much room for improvement. For example, when it comes to the tribal courts, they may represent some hurdles, and also we need more coordination when it comes to the international scenario. We need to promote the exchange of experiences. We want to understand what is the institution's role, what are the mediators' role. You know, we lack information, we lack an exchange of experiences, and this is a very important topic. So just to conclude, I would like to say that I hope peace will prevail. We need to live in a world without conflicts. We need to protect our children. Thank you very much.
So thank you, Judge Mahmoud, for highlighting the situation in Jordan. So as we can see, we have a representative from the state of Jordan, and from a religious system. We have a representative from the state for a criminal system in Palestine. We don't have, unfortunately, customary actors today. You're not, I'm not. But the point of this presentation, of this parallel session, is to highlight the fact that access for justice and youth will be much better if there is a good collaboration between the different juridical systems. Civil law system, the common law system, the religious systems, and the state systems. So we are happy also to hear what is happening in Palestine with on the criminal mediation. That is a good example. It's a good practice, and it would be great if this kind of practice could be also scaled up in some other context. Same for Jordan. The fact that state religious actors are collaborating with community actors is also a very good practice. So here we are. We still have a few minutes for questions before the lunch. So please, is there any question in the room? Okay, one there. So you'll have to. But we don't have any micro, I don't think.
Yeah, no.
No, we don't. We have this.
Sorry.
Yeah.
Good morning. Well, first of all, I would like to thank all the representatives of different countries for your presentations. It was very fruitful. I would like to present myself. My name is Mahdi Diana. I am a judge in Algeria. So I have a question for the Palestinian representative. It was very interesting to know that there is a mediation system concerning the children, in which the mediators are from the society. It's quite different for us in Algeria. Actually, the mediation it's only for adults, because we try to provide the maximum benefit and for children, because they're not they're minors. So I would like to. My question is concerning the meditation in children's affair. Is it in any affairs, or just criminals, or just for family affairs? So I would like to know. If you want, I can ask my question in Arabic, or it's okay. It's clear. السؤال تاعي it's clear? Okay, great. Thank you.
Merci.
شكرا على السؤال بس لأنه
Well, thank you very much for your question. Well, actually, I wanted to be short, so that's why I could not go into detail. I will go into detail now, though. Now, in Palestine, the crime justice is part of the juvenile prosecutor's office. Only when it comes to small infractions. That means any child between 12 and 18 years old, if that child commits a small infraction, that case is given to mediation. So the mediator would be the one deciding. We have successful cases. 75% of what goes through the mediator does not reach the courts. However, we don't have mediation for crime affairs, because in that case, repair measures, it's not included in the process. So if children suffer a violation of the rights, for criminal cases, again, mediation would work differently, or actually we wouldn't have mediation. I can give you more details later. Palestine is the only country that has used mediation when it comes to civil responsibility or liability. So this proposal has just been made in Palestine, as I said. Now, when it comes to common law or public interest matters, we support, therefore, having the best interest of the child at first, but only on the matters that we represent. So that is why I'm saying that we have experienced many successful cases in mediation.
Taher, yes, please.
¿Alguna pregunta más?
طيب شكرا للمنظمين.
Thank you very much. I'm an expert when it comes to children justice, and I have a question for Mr. Saher. The experience of Palestine is very interesting, and we are actually following it. We know it has been very successful, and we would like to have the same model. Now, I would like to ask two questions or mention two aspects. Now, it is a good time to reform juvenile laws in the whole Arab world. We need to speak about children. Now, when it comes to mediation, the mediator itself can be under a lot of pressure. So maybe it would be interesting to have a committee of mediators, and maybe the General Prosecutor's Office could, could supervise this. Thank you very much for your question. Now we are aligned. We are actually following closely experiences. I will answer briefly. In the Palestine system, once the mediator has been assigned by the prosecutor's office, a follow-up is done. So there's someone doing a follow-up of the mediator's work per se. And I understand your concerns. We have closely followed the mediator's work, and there has never been an infraction because of pressure. And this is because we have clear working mechanisms. We have a clear law within the public prosecutor's office, and case by case, there is a clear assessment, a clear follow-up. So the public prosecutor's office actually knows what is happening during the processes. And if the mediator makes a mistake or an infraction, then that person would be put aside. And if there is bad intention behind that mistake, if there is corruption, for instance, that person would be brought to court. So, to answer to your question, we do a follow-up, indeed, of the mediator, and we try to safeguard the best interest of the children. That is our main goal. I do understand your concerns. At the moment, when the mediator starts the job, they will not begin working on children cases. That person will start in other cases before they enter into children's justice.
So, dear participants, dear colleagues, speakers, thank you very much for your presentations. Thanks to my colleague also Farah for preparing this presentation with Judge Taher, Judge Mahmoud. Thank you very much.
Sure.
So the lunch is ready. So I think we'll end now. Thank you very much et bon appétit.
Thank you, Ian.